For Mr. Nicole in regards to a sentencing with Casey Staley.
Stalen's in custody?
Yes, Your Honor.
Did you already speak with?
No, I haven't yet.
Okay.
So I did, when he was brought up, if I had a moment.
Mr. Hester here with William Hill.
I am. I have 3 clients. I've got Mr. Marquise Cook in the courtroom. Ms. DeMay is my other clients in the courtroom, and then Mr. Hill is waiting in the hallway.
Okay, are we running Hill?
Yes, Your Honor.
And what are we doing with, is there a waiver for Cook?
Yes, Your Honor. So a waiver for Mr. Cook.
Okay, we're on the record in the matter of the people of the state of Michigan versus Marquise Cook, file number 23-00099. Council parents.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Edward Hess appearing this morning on behalf of Mr. Cook. Mr. Cook is in the courtroom, standing to my right behind the counsel table.
How are you, Mr. Cook?
Yeah, how are you?
I'm doing well, thank you. Today's the date and time that's set for a preliminary examination. My understanding is that there is a unconditional waiver to the circuit court, and the people are offering for the defendant to plead guilty as charged with sentencing under HYTA. Is that accurate?
That's correct, Your Honor.
Yes, Your Honor. Thank you.
Okay, and so, Mr. Cook, you understand that you have the right to have a preliminary examination here in the district court. And at the time of the examination, which is scheduled for today, you have the right to have the prosecution meet their burden. So it's their responsibility to provide sufficient evidence to establish that there's probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? You want to waive your right to examination today? Okay, can you speak up?
Yes.
Okay. Okay, anybody threatening you to get you to waive your preliminary examination?
No.
Has there been any promises made to you in exchange for you waiving your right to preliminary examination?
No.
Okay. And you understand that the waiver is unconditional, so that means you can't come back in a couple weeks and say, you know what, I wish I had had my exam, I want to have it. You understand that it's unconditional. Once you waive it, it's gone.
Yeah.
Okay. And that's your signature here on this document?
Yes.
Okay. Referring your waiver to be made freely and voluntarily, the matter will be bound over to the circuit court. Excuse me, your bind over date is going to be February 8th, 2023. You do not need to appear in court on February 8th. That's the date they get the file from this court, okay?
Okay.
Your next court date will be in circuit court. It will be a pre-trial. You and your attorney will be made aware of that date. Do you have any questions at this time?
No, I don't.
Okay, bond was set at 1,500 personal recognizance. That will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing for the defense.
Thank you. You're all set, sir.
Thank you. Mr. Cook, call your next witness.
On the record in the matter of the people of the state of Michigan versus Chloe DeMay, file number 23-00088 FY, council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Thank you, Your Honor, and good morning. Edward Hess on behalf of Mr. May. Mr. May is to my right at the counsel table.
How are you, Mr. May?
Fine.
How are you?
Good, thank you.
Thank you. You can stand up. Today's date and time set for a preliminary examination. My understanding is that there's a request to adjourn.
Your Honor, that request is no longer needed. I was able, excuse me,
Take your time.
I was able to get on the phone with the victim, and my victim is present in here today.
Okay, are we running an exam?
Ready to proceed, Your Honor.
We're gonna run the exam?
As far as I'm aware, yes, Your Honor.
Okay, I'm not gonna go, I don't believe we're starting with that one first. But I had a note that this was going to be adjourned, which is why I called that case. So we'll call that when we're ready to run it, okay? We're off the record. And we're running Hill as well.
Yes, Your Honor.
You're not on Bullock, is that correct?
No,
It's Jared Austin, Your Honor.
No, are you running Bullock?
Yes, Your Honor.
Okay, you are. Okay, I don't know why I thought Mr. Pfeiffer was on there. Okay, and then who's handling Lopez?
Jared Austin as well, Your Honor.
Okay, is Mr. Austin here?
You stepped out.
Okay. Terrence Nguyen or Nguyen here?
That's Mr. Colriders.
Have we seen Mr. Nguyen?
I don't believe Mr. Colrider has seen him, but I don't want to speak for him. Oh, speaking of.
Is your client, Mr. Nguyen, present?
He is not, Your Honor. Our office doesn't have a phone number or email. I know he appeared on Zoom last week. Supposed to contact us.
Okay, give the number we have in the file. It says it's his daughter's number. Is that the number you all have? Okay, well, we will issue a bench warrant. I'll hold it till the end of the day in case he appears. Mr. Austin is here. On the record in the matters of the people of the state of Michigan versus Davina Lucia Lopez, file number 22-03530. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Thank you, Your Honor, and good morning, Jared Austin, appearing on behalf of Ms. Lopez.
Okay, how are you, Ms. Lopez? Okay, the date and time set for preliminary examination as well as a PA 53 violation. How are we proceeding on it?
Your Honor, at this time, I spoke with the complaining victim on the underlying charge last night, and she informed me that she has COVID. She was tested positive 3 days ago. She told me that she could put a mask on and be here today, but I informed her that that was not necessary. So at this time, I'd be seeking an adjournment, Your Honor. I am prepared, however, to run the PA 53 violation. I have the victim here on that.
Mr. Austin.
Thank you, Your Honor. Ms. Lopez is here and we are ready to proceed on both hearings. I understand the people's request. I would leave it at the court's discretion.
Thank you. I don't want people in the courtroom with COVID, so I will grant the request to adjourn. And if you're ready to proceed on the PPD at this time.
We are ready to proceed, yes, Your Honor.
Okay, sounds good. You can call your witness.
The people will call Jaden, but she is.
You're fine. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury. Okay, you can have a seat there. Okay, there's a microphone that's in front of you. I have a court recorder. She's sitting directly behind you. Her job is to take down everything that's being stated here today, so your responses must be loud, clear, and verbal, okay? And then, is that a yes?
Yes.
So if you say, that was my next instruction. I'll ask you if that's a yes or a no, because we need to make sure it's clear on the record, okay? So you want to use yeses and nos, no head nods, no shakes. If there's an objection from either of the attorneys, you would stop speaking immediately. I'll make a ruling on that objection, and then I'll tell you if you can give that answer or not, okay?
Okay.
State your first and last name and spell it, both of them for me.
Jaden Pavona. It's Jadeeyn. P as in Paul, A, V as in Victor, O-N.
Counsel, you can proceed.
Thank you, Your Honor. Mr. Pavona, where do you live?
I live in 1974. You want my address?
No, that's fine. On the 12th of January, were you in the area of K North Road?
Yes.
And what were you doing in the area of K North Road?
I was coming home with my 16-month-old daughter.
And is K North, is that address, would it be 5510 K North Road?
Yes,
Is that in the city of Lansing,
yes,
Ingham County, Michigan?
yes,
And so you say you were on the way home with your daughter.
yes.
What happened when you were on the way home with your daughter?
I got home and I saw Avina in a car with her friend, and I backed in, so I always back in, and as soon as I backed in, the car that they were in pulled out in the middle, and they were just sitting in the middle, and I saw them sitting there, so I decided to pull off because I have my daughter with me.
So you could see into the car and you could tell that it was
Yeah,
Avina Lopez. And is Avina Lopez here in the courtroom today?
yes.
Could you point her out and describe something she's wearing?
A blue, white, and maroon.
Will the record reflect that the victim has identified the defendant?
Any objection to identification?
Without objection.
So noted.
And so you backed in. Why did you back in? Why did you stop?
I always back my car in, so I was just parking my car.
Okay.
Yeah,
So were you there to drop off your daughter or were you there?
I was there to go home. I was trying to go in my house.
And what happened after you stopped?
The car that they were in, they were like in the middle of the road, just sitting there. So in my head, I figured that they were waiting for me to get out of the car, and I had my baby with me, so I drove off and they followed me in my car
And why didn't you get out of the car?
because I had my baby with
Were you afraid?
me. I would say because of the threats of Avina making about shooting my daughter, yes,
So Avina's threatened to shoot you before?
yes,
Has she threatened to shoot your daughter before?
yes.
Was this over social media? Was this,
It was.
how were these
through-
threats conveyed? Sorry, there.
Sorry. It was through text messages on social media, but there were also videos of guns sent to me and voice messages from Avina sent to me.
What did those voice messages say?
She said that she has a gun and she's going to use it.
I'm going to object those statements. They're going to be talking about statements that come from voice messages. I think the best evidence of those would be the actual voice messages themselves.
These were statements that were made via voice message.
Yes.
Did you want to respond to the objection?
Your Honor, she was personally there. She knows what these voice messages say. I can play the voice messages, but a brevity of keeping it brief for the court. I was happy.
Well,
to
we have the
testify.
voice messages, and so if there's an objection, I'll allow you to play them.
Yeah. Yeah, may I approach?
You may.
I'm showing the witness what's been marked as people's proposed one. Take short. I'm just gonna take it. I don't have the sound. Do you recognize that video?
Yeah, I do.
Yes. I'm just gonna. do this. Sound is not working, of course. My sound isn't working. Do you remember what day that video was sent to you?
That was probably 2 months ago, maybe. We got into an argument a couple months ago. We haven't spoken because I blocked her, and then I came home and they were following my car.
Oh, sorry, that was marked people's proposed two, not one. My mistake on that one. Got it.
Yeah.
Is that a fair and accurate representation of the video you saw on that day?
Yeah.
Okay, this was the video that you said you were sent. Who sent you the video?
It was, I had somebody send it to me, yes.
Who sent it to you?
My friend sent it to me. I'm not friends with Alina on any social media.
Okay, so someone forwarded you this video?
Yes, it was the same day that she was posting about me on Facebook and texting saying, I sent him voice messages that she personally sent me. Saying
Okay.
that she was going to shoot me, but that was just a video that I also included.
This was a video that was posted on social media?
Yes,
Okay, and it was, you said directed to you?
yes,
Okay. You can proceed, Council.
Thank you. And it fairly accurately represents the video that you saw on that day.
yes,
And did you send this to the police officers?
yes.
You know, at this time that people would request that this video be admitted into evidence, people's posts.
Mr. Austin.
Or two.
Your Honor, I don't really have an objection foundationally. However, I just want to make sure I heard correctly about the date of this supposed video. I thought that what I heard the witness say this was approximately 2 months ago, which if that's the case, then I think my objection would be to relevance that she's here for a PA-53 violation if this occurred prior to her being on bond conditions for this case, and I don't think it would be germane to this hearing.
Mr. Ring?
Your Honor, 2 months ago was still put it in the November date range. This incident for the bond hearing on this incident occurred back in November, and 2 months prior was still put this in the relative range of that November date and time frame, Your Honor.
What November date and time frame?
This incident, or the initial incident that we're here for on the bond violation occurred on November 13th, Your Honor.
She wasn't arraigned until January 3rd. Is there another matter that I'm confused about? On this matter? Since she was arraigned in January.
On the underlying matter?
Correct, so she would not have had bond conditions in November.
Your Honor, this is a reissue from our office, so she was on bond prior to this issue.
Oh, gotcha. Okay, and so are you offering this video to prove the bond violation or for another purpose?
Your Honor, I'm offering this video to show why she would be in fear and why she would be in fear that day and of the threats that were made to her prior to.
Gotcha, okay, objections overruled.
Permission to publish, Your Honor.
You may.
Just gonna- You want me to put it on the screen or?
Yeah, we need a bit, we need the. This for until the end of the day.
Is it connected?
I can hear.
Y'all dumbass bitches don't learn until I get my blick and shoot the fuck out of y'all.
Did it say blick?
Yeah. Yes.
Oh, okay, thanks for that clarification. Do you know what a blick is?
It's a gun.
Okay, so that's
It's
commonly
another
used in
word
this
for a gun. Yes.
terminology for a gun. Okay. sounds
Yes.
And was that the first time she had threatened to shoot you?
No.
Did she threaten to shoot you after that? Anytime after that?
Yes.
Has she, and so after she threatened to shoot you, you were in that parking lot and you were leaving. Did she follow you?
Yes.
Did you send you any videos of her following you?
Objection leading.
Sustained.
I'll rephrase.
Thank you.
How did you know she was following you?
Because I pulled out and their car was sitting in the middle waiting for me to do something, and they followed me all the way out of my apartment complex. Not really sure how to explain it.
This is the date of January 12th we're talking about, correct?
Yes,
That's
Okay.
correct. Your Honor.
yes, and yes.
Did you receive any social media posts on January 12th?
I did,
Did you receive any messages on January 12th?
I did.
And what were they?
I received a video from somebody who has her on Snapchat, Avina on Snapchat, and it was a video of her following my car, saying my name and zooming into my license plate.
Objection, Your Honor. Same objection that I made earlier, Your Honor. If we're going to be talking about videos and messages, then I think the best evidence of those would be the videos and messages themselves if we have.
Did you want to respond to the objection?
Your Honor, I can play the video. That's fine.
Okay. Video.
I'm showing the witness what's been marked as people's proposal 2. Is that a video that was sent to you on January 12th?
Yes,
Does that video fairly and accurately represent the video that was sent to you on January 12th?
yes.
Your Honor, I move for admission of the proposed 2.
Any objection?
All right, I would object based on, I think, authentication. I think a witness can testify that may be fairly and accurately depicts what she saw or what she sent, but we don't know who created it, who sent it to her, what changes or alterations may have been made to it prior to that.
Okay. Couple things. You said it was people's proposals. There were 2. Didn't we redo that?
The flash drive has only been marked as 2.
Okay,
There are
so-
multiple
So it's just a different video?
2A, 2B.
2B, okay, 2B. Okay, and did you want to respond to the objection?
Can you please restate that objection?
Yes, Your Honor, I'm objecting to authentication. The witness can testify that it fairly and accurately depicts what she saw, but we don't know who sent it to her, who created it, what changes or alterations, if any, may have been made prior to that.
Questioner.
I can ask a couple questions in order
Please
to
do.
do that.
Thank you.
Do you know what Ms. Lopez's screen name is on Snapchat?
Yes, it was Avina, but after she saw that I got the video, she changed it.
And do Snapchats have the screen names on the videos of the people that post them?
Yes, they do.
Yeah, at this time, I'd move for admission. I think that fairly encapsulates the fact that
Who sent her the video?
the defendant.
Who sent her the video?
Somebody who has her on Snapchat sent me the video, and then I went and looked myself and saw it for myself.
To the best of your knowledge, has this video been altered in any way prior to it being sent?
No, it's just a screen recording.
Okay.
Yeah.
Any additional questions?
I have none relative to the video, Your Honor.
You're continuing your objection?
I am, Your Honor. Yes.
Objections overruled.
Thank you, Your Honor. Permission to publish, Your Honor?
Yes.
Okay.
And I caught you lacking on the wrong day. Jaden Pervona in the cut. Wow.
No further questions. This time, Your Honor.
Okay, well, I need to see the video again. That was so quick. I don't even know what I saw.
From East Lansing, and I caught you lacking on the wrong day. Jaden Pervona in the cut.
Whose white car is that? Okay.
And I don't know if the video that it uploaded wrong, but she had zoomed into my license plate and like she got me driving off as well.
I don't want to object, it's non-responsive.
Okay. Well, it is facts whose car it was. It's identifying that it showed, there was the actual video that shows her license plate, identified that it was her car.
Yeah.
So the objection's overruled. Okay, no additional questions?
No, Your Honor, thank you.
Okay, cross-examination.
Yes, Your Honor, may I have a brief moment? So this incident in the parking lot that you were talking about, were you by yourself?
No,
Who were you with?
my 16-month-old daughter.
And that was it?
Yes.
And the time period that we're talking about, this was in the afternoon, is that correct?
Yes.
And time of day when it was daylight out, correct?
Yes.
And did you see any other people out and about in the parking lot when this was occurring? Better know you didn't see anyone else.
I saw somebody driving the car with Vina, but I didn't see anybody. I wasn't paying attention to anybody else in the parking lot. No.
And when did you report this to the police?
Right when it happened?
You did that with a phone call?
Yes.
I think it's all a question of that.
Okay, I'm just still a little lost about timeline here. On the date of January 12th, you're stating that you saw them following you?
Yeah.
Was there any threats made to you on that date that involved a gun?
No,
Okay,
there were threats made prior to that.
got you. When you say prior, you mean back in November? Or were
I
those threats
don't-
made in January?
There were threats. I think, I don't have my messages in front of me, but we have been arguing and she's been threatening me from November to now.
Okay, you provided these threats to the prosecution?
I did.
Okay. And those threats that, any of those threats that you received in January involved the threat of using a gun?
I am not sure.
Okay, any of those threats in January involved threats of assaultive behavior?
Yes.
Okay. And what threats were made to you in January about assaultive behavior?
She said that she was going to fuck me in my baby cup.
Any further questions based on that, Mr. Ring?
Just a couple, Your Honor. What, do you remember what date those threats were made?
I don't.
No further questions. Your Honor.
She said she provided evidence of that to you.
Yes, Your Honor, I do have some screenshots of messages, but I don't have dates, and she couldn't confirm the date on that, Your
Okay.
Honor, so.
Sounds good, thank you. Cross-examine based on my questions.
No, Your Honor, thank you.
Thank you. May this witness be excused?
Yes, Your Honor.
Thank you, Ms. Pavona. You may be excused. Any additional witnesses?
No, for the people, thank you, Your Honor.
Okay, is the defense calling any witnesses?
Or will I only have that presented, Your Honor? Thank you.
You can make argument.
Your Honor, Ms. Lopez is out on bond, and part of that bond condition is not to possess, purchase firearm or other dangerous weapon. Another part of that is do not harass, intimidate, beat, molest, wound, stalk, or threaten, engage in any other conduct that will place a following person or child in fear or of bodily injury, spouse, former spouse, individual with whom has a child in common, a resident of the former or the defendant's household. Your Honor, I understand that this victim is not the named victim in the complaint, Your Honor. However, there was a video and she did receive threats of a gun, and she testified that she did receive threats that she had a gun, and that she was not going, that she would use it. We saw a video of the defendant holding a magazine in her hand, indicating with that magazine that she would shoot and that she had a Glick and she would use it, Your Honor. And we confirmed with the victim that did mean a gun, Your Honor. Your Honor, based on that, I would ask that you find the defendant guilty of a violation.
Ms. Johnson.
Thank you, Your Honor. This type of hearing, Your Honor, have a higher burden. They have to prove Ms. Lopez violated PA 53, I believe, beyond a reasonable doubt. The video, the initial video that we were talking about here, the evidence was clear that that was a video from 2 months ago in November. And even Mr. Ring, I believe, conceded when we were having an objection and argument about that it doesn't appear that that can be something that could be used substantively to prove that Ms. Lopez violated her bond conditions in this case, because she was not on bond conditions for this case until early January. So I would ask the court not to consider that, or I don't think the court could consider that as substantive evidence that she violated her bond in January for something that happened in November when she wasn't on those bond conditions. That may give some framework as to the witness's state of mind, but I don't think it goes beyond that. And the second video that we saw, the brief video in the parking lot, I don't believe there was anybody that identified who the voice was in that video, but I don't think any statements that came from that video could be construed as threatening, assaultive, intimidating behavior. So based on the evidence that we have presented here today, Your Honor, the witness indicated that there may have been some such statements or threats sometime in January. We didn't have any substantive evidence of that. The witness could not be specific or pinpoint down when that occurred. Based upon that, Your Honor, and based upon the evidence that has been presented, I would ask the court to find Ms. Lopez not guilty of violation.
Thank you. Okay, I've heard the evidence via testimony and reviewed the video played in court today. As to the allegation that Ms. Lopez has violated the terms of her conditional release, that being PA 53, by having a firearm, I'm not satisfied that there was a firearm that was used from the time that she was placed on bond in this particular matter, which was back on January 3rd, because the video played was from a couple of months ago. And albeit she may have been on bond at a certain time for the case that was previously issued, it's not the matter that's before the court now. This PA 53 violation is very specific as to January 12th. That's what the police report indicates. However, whether or not she violated the term, she was also advised that she was not to engage in any assaultive or threatening behavior. We did also see a video that demonstrated someone whose voice sounded very similar to Ms. Lopez. I know that because Ms. Lopez has spoken in my court several times, including today, and she wasn't being spoken to directly. So I can identify her voice myself. Sounds like Ms. Lopez speaking, and following were appearing to be waiting in a parking lot for the person she identified as Pavona. Ms. Pavona was present in court. She identified her vehicle in the video. That video was from January 12th. And so the concern I have is I don't know if that portion or segment of the video that was demonstrated here was sufficient enough to make me believe beyond a reasonable doubt that there was an actual threat. But I do believe that there was some intimidation there. The only issue is that Ms. Pavona is not the named individual on the PA 53 that states she's not to intimidate. And so I'm not satisfied beyond a reasonable doubt that there was a bond violation. So I'm going to dismiss the PA 53, but you're getting a warning as the last warning.
I won't mess up this time, I promise you.
You don't threaten anybody, not even a fly. You understand?
Yeah, yes, I do.
You shouldn't even be dreaming about firearms right now.
No, I'm dreaming about my kids trying to get from that kind of stuff.
That should be your focus. You shouldn't be fighting with any other females. How old are you?
20.
Grow up. Are you working?
Not currently.
Get a job. Get yourself busy so you don't have time to be sitting in parking lots waiting for people. PA 53 is dismissed. We're going to reset the preliminary examination. February 23rd at 1:30. February 23rd at 1:30. We'll get you a copy of your notice to appear. By then you should have a job, okay? Because everybody's hired.
Yeah. Well, I can always work with my sister, but she's just not the best person ever.
Gotcha. Okay. Any additional matters for the record?
Nothing about the people, thank you, Your Honor.
Nothing on behalf of Ms. Lopez, Your Honor, thank you.
They're all set. We bring Mr. Halen up for Ms. Donald. Is it Mr. Halen?
No, it's Mr. Casey.
Mr. Sorry, Mr. Halen, I'm sorry. Yes. We're on the record in the matter of the people of the state of Michigan versus Lyle Allen, file number 23-00156.
Yeah.
Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Thank you, Your Honor. Good morning. Jared Austin is hearing on behalf of Mr. Allen. Bigelow, I believe, after treatment in the hallway. He's in a wheelchair, Your Honor.
Mr. Allen, I'm right here next to defense counsel. I'm doing well. How are you?
Better.
Okay, today's the date that we're going to address your failure to appear in court yesterday. You were supposed to be in court for a probable cause conference yesterday. You did not appear. I do recall, did you leave a voicemail on my campaign line?
Yes, I was panicking. I didn't know how to find you, and it showed up. I hit the button call.
What made you think that you should go on my campaign line and leave a voicemail and not call your attorney?
I called all the other numbers, City Hall, the prosecutor's office, and nobody was answering. It was always that.
Did anybody tell you you're not supposed to talk to the judge directly?
Always that. No pun intended. I really was trying to get.
So what's the pun?
I wasn't trying to. I don't know. I just.
I love a good pun. So what was the pun?
I was not trying to do anything wrong. I was trying to
Okay.
get an answer.
Well, I had already said I was going to hold this for 48 hours because I assumed there was some level of miscommunication as to why you weren't gonna be here. Your attorney waited, and you did not appear. So all you needed to do was get in contact with your attorney. And you should be in regular communication with your attorney. You do understand that?
Yes, ma'am.
Mr. Austin, you're not his attorney, correct?
I am.
Oh, you are? Okay. Oh, I don't know why I thought it was Mr. Collier. Okay, nonetheless, you need to make sure you're in regular communication with your attorney. This matter is scheduled for preliminary examination on the 3rd of February at 9:30. Are we continuing?
Well, Your Honor, we have reached a resolution. Mr. Allen is willing to enter a misdemeanor plea today before court is set.
What's the offer?
The offer was for Mr. Allen to plead to an added count 3 use of methamphetamine, and people would dismiss counts 1 and 2.
Okay, he does want to accept that at this time.
Yes,
Did he
yes, he
complete it
has,
in
Your
vice
Honor,
right?
and he has executed in vice rights.
Right, John?
Thank you. Okay, Mr. Allen, again, the offer is for you to plead guilty to added count 3 of use of methamphetamine. The people will dismiss the remaining counts. That's a misdemeanor. Maximum penalty is 1 year and or $2,000 in fines. Do you want to accept that offer today?
Yes, Your Honor.
Can you raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you put your hand down. Okay, Mr. Allen, I have an advice of rights and plea information sheet dated for January 27, 2023. Is that your signature?
Yes.
Okay, did you read this document?
Yes.
You understand each of the rights listed here?
Yes.
Do you have any questions about these rights?
No.
Do you want to waive these rights today?
Yes.
Okay, so that means you're willing to give up your right to the presumption of innocence in this matter. You are innocent until proven guilty. You understand that?
Yes.
Okay, you're willing to give up your right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt?
Yes.
You're willing to give up your right to see, hear, or question any other witnesses the prosecution intends to call, or to call your own witnesses or present evidence at trial that you believe would further defense to these charges?
Yes.
You also give up your right to remain silent and have silence be used against you. You understand that?
Yes.
Are you currently on probation, parole, or out on bond or anything other than this matter?
Yes.
Which one? You have another matter pending?
Judge Allen failed to appear and bailed myself, I bought myself out.
Okay,
That's it.
okay. And have you discussed with your attorney how, if at all, this plea could impact your pending cases?
Yes. Yes.
Okay.
Yeah, yes.
Thank you. You understand that a guilty plea can result in a conviction that you may need to report to your current employer?
Yes.
You also understand that you may need to report a conviction on a future job application. And a guilty plea can result in a conviction that may have impact on travel or immigration status that you may be seeking. You're aware of that as well?
Yes, sir.
Okay, and are you pleading guilty because you believe you're guilty?
Yes.
As to the added count 3 of use of methamphetamine, how do you plead?
Guilty.
Factual basis?
Facts.
Uh,
I'm sorry, Your Honor. I'm sorry.
Mr. Allen,
Yes.
I want to take you back to January the 17th of this year. Do you recall the events of that day? True, you were at or near the location of 900 Long Boulevard in Lansing, Michigan.
Yes.
Is that here in Ingham County?
Yes.
And at that date, time, and location, did you have in possession on your person controlled substance known as methamphetamine?
Yes.
You were aware that you had that?
Yes.
And did you have any type of prescription or license to be in possession of that? And that was an amount that was intended for your own personal use, is that correct?
Any questions, Mr. Ring?
No questions, thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing March 31st at 8:30. March 31st at 8:30. You can appear via Zoom if you have video capabilities. You also would need to be in a place that's quiet so that we can conduct the business of the court, okay?
I'm not gonna use it. I'm not gonna see.
That's completely fine. We're always open. You can, during business hours, you can come right on in. When you leave here today, though, you're gonna go down to the 5th floor. You're gonna go to the probation department. They're gonna get you set up for a pre-sentence investigation. I'm ordering that you undergo a evaluation as to substance abuse, okay? Do you have any questions today? What's your question?
My plea to be forgiven.
Forgiven for,
But I-
you'll be forgiven, but you still got a sentencing. Okay,
I apologize once again for the phone.
you're fine. I just wanted to make sure you knew that you needed to call your attorney, not me.
Well.
Sounds
I knew
like
I had
you-
to
sounds
answer
like you got-
first, so I said, I better call her first. No,
Yeah,
I
but you don't
wasn't.
want to come without your attorney.
I know.
You don't want to start leaving voicemails for judges
You're right.
and saying stuff that could be used against you. Okay? Any other questions? Any additional matters for the record?
No, no, people, thank you, Your Honor.
One additional matter, if I may, Your Honor.
Yeah.
Mr. Allen is on GPS tether, and I believe that's for this case. I suspect that was because of the assaultive charge was associated with this case. Now that has been dismissed, I would ask the court would consider removing that requirement of pretrial release.
GPS tether is removed. Any additional matters?
Nothing further on that, Mr. Allen.
Thank you. We'll get you some paperwork so you can go to the fifth floor. Okay, sir?
Thank you,
You're welcome.
Thank you, Judge.
No problem. Mr. Wayne, we have here. Who's next? For exam. We have a couple of pleas, I think.
Have a couple, please, Your Honor.
Mr. Is it Yazid?
Yazid,
Yazid is gonna be a plea?
correct.
Okay,
He's in custody.
we'll have him brought up. And what's going on with Mitchell?
That will be a plea. We're ready on that one, Judge.
Okay. We'll get security to bring up Yazid for the plea. And we're on the record of the matter of the people of the state of Michigan versus Evan Patrick Mitchell, file number 22-02861, council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Aaron Robinson, Assistant Public Defender for Mr. Mitchell.
Hey, how are you, Mr. Mitchell?
Hello.
How are you?
Good.
Today's the date and time that is set for a preliminary examination. Who has the plea sheet?
I do, Your Honor, if I can approach.
Yes. Thank you.
Please sheet in this place of breaks.
Okay, and Mr. Mitchell, the offer from the people is for you to plead to an added count 2.
You count two and an account.
Plead to count 2 and added count 3 of breaking and entering without permission under MCL 750.115A. The added count 3 is a misdemeanor, maximum penalty 90 days and or $500 in fines. Count 2 is assault and battery. And that's a misdemeanor, maximum penalty 93 days and or $500 in fines. People will dismiss count 1. That, would you understand your offer to be, sir?
Yes,
You want to accept that offer today?
yes,
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
yes.
Thank you. Keep your hand down. Thank you. I have an advice of rights and plea information sheet. There is a signature on it. However, the date is for January of last year. Is this your signature?
Yes, it is.
Okay, can I change this to January 2023?
Yes,
Thank you. Common error. Okay, and you read this document?
yes,
Do you have any questions about these rights?
no,
Okay, you understand each of the rights there?
yes,
You understand that in order to accept this offer from the people, you have to give up the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
yes.
You want to waive that presumption of innocence today?
Oh, no.
Okay, so then you don't have to waive it if you don't want to.
All right.
Okay, yeah, yes.
Do you want to waive your presumption of innocence? You don't have to. She can't make you waive it.
Do you, if you want to enter, then you have to give the presumption of innocence, right? If you want
Yes.
to go to trial, then you can do that. But you-
I just want to plead guilty,
Okay. Why do you want to plead guilty?
because I just want to hold myself accountable for what happened, even though I assume things about him and I can't prove those things, so there's no point of going to trial, I guess.
Okay. Well, we're not at the place of trial yet, but we are at the place where there could have been a probable cause established in this matter. But you're willing to give up your rights, and that includes the presumption of innocence? Do you believe you're guilty?
Yes,
Okay. And so you understand that you're gonna give up your right to have a trial by jury?
yes,
You're gonna give up your right to have the prosecution have to prove each element of the charge being brought against you beyond a reasonable doubt?
yes,
Okay, you're gonna give up your right to question or cross-examine any of the witnesses if they wanted to call?
yes,
You're gonna give up the right to call your own witnesses or present evidence at a trial that you believe would further a defense or prove that you're innocent to this. You understand that?
yes,
Okay, you're gonna give your right to remain silent and not have silence be used against you. You understand that?
yes,
You understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to put a conviction on a future job application.
yes,
You understand that a guilty plea can result in a conviction that may have impact on immigration or travel status that you may be seeking.
yes,
Okay. Are you on probation or parole?
no,
Do you have any other matters pending?
no,
As to the as to count 2 of assault and battery, how do you plead?
guilty,
And as to the added count 3 of breaking and entering without permission, how do you plead?
guilty,
Factual basis, counsel.
Yes, Your Honor. Mr. Mitchell, on or about October 21st of 2022, were you present at the location of 1022 Eureka Apartment 1?
yes,
And that's in the city of Lansing, County of Ingham, state of Michigan, correct?
yes,
And did you enter the dwelling of a Mr. Jeremy Johnson?
yes,
Did you have permission to enter that dwelling?
no,
And when you were inside of the dwelling, did you hit Mr. Johnson?
I would say I pushed him, I never hit him once,
Pushed. So you pushed Mr. Johnson, and that wasn't in self-defense, was it?
no,
Any questions from the prosecution?
Nothing for the people, Your Honor. I think that's assessments.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing March 31st. At 1 p.m. Prior to sentencing, and actually when you leave here today, you need to go down to the 5th floor to the probation department so that they can get you set up for your pre-sentence report and investigation, okay?
okay.
I'm also going to have you undergo a substance abuse assessment, part of your investigation, okay?
Okay,
Do you have any questions for the court at this time?
no,
Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
No, Your Honor, thank you.
Thank you, you're
thank you,
awesome.
Your Honor.
Thank you. Have a seat. We'll get you some paperwork to take down to probation. Okay, and Mr. Holmes, your client is in here ready to run?
Both my clients are present. Mr. Hill's at the hallway, Mr. Mays in the building.
Demay is going to be ran as well, correct?
Correct, Your Honor.
Okay, we can get ready. I'm gonna do, who is this?
Yazzie.
So Yazid, we're gonna handle this plea. I need to do a sentencing and then we'll run Mr. Hill.
Thank you.
Mr. Austin, you ready on Nazib?
Yes, Your Honor.
Okay, sounds good.
I didn't finish it. Have it, but I didn't finish it.
On the record in the matter of the people of the state of Michigan versus Malik Yazid, file number 23-00107 FY, council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Yazid, who's present with me in council today.
How are you, Mr. Yazid? Today's the date and time that's set for preliminary examination. I have an offer from the people. They're stating that they're offering for you to plead guilty to added count 3 of larceny less than 200 under MCL 750.3565. They'll dismiss counts 1 and 2. The larceny less than 200 is a misdemeanor with a maximum penalty of 93 days and or $500 in fines and or 3 times the amount stolen. You understand that offer?
Mhm.
I'm sorry?
Yeah, I do.
Okay,
I got a question though.
yes.
If it's possible, if I can get out and, cause I get a check, I get a $900 check a month. And my check, I got like 2 checks in my brother's mail. I stay right behind Lansing Mall, West Mall Drive, apartment 15. It's right, the apartment right next to Apple Tree Lane, the senior citizen with my grandma and my brother. I can go pay them, but I just gotta go grab my check out my brother's mailbox and my ID, but I got that. But so I can pay them back or something, because I got very important stuff I gotta take care of my grandma and my brother and stuff. I gotta go pay rent and everything, but my rent's only $300. I paid it for my brother. I have my capital payee, her name is Julie Robertson. So I get money, so I just need to
Okay, well, we can address your bond after we deal with this portion, okay? I have a police report. So
Correct,
is
Your
this a
Honor.
no
It's a-
contest plea?
It is.
What's the reason for the no contest?
Mr. Yazid lacks complete memory, Your Honor, due to being under the influence.
Okay, I have an advice of rights and the information sheet here with today's date on it. Is this your signature?
yes.
Okay, did you read this document?
Um,
We'll give it back to you so you can read it. And ask your attorney any questions if you have any questions at this time, okay? We're off the record. We'll handle Mr. Stahelan. We're on the record in the matter of the people of the state of Michigan versus Casey Stahelan, file number 22-02640. Council appearance.
Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Scott Nickel with the defendant Casey Stalin, who is present and sitting in the courtroom.
Thank you, Mr. Stahelan. How are you?
All right.
Today's the date and time that's set for sentencing. I do have a pre-sentence report here. And a recommendation. Did you go over that with your client?
I did, Your Honor.
Any additions, corrections, or deletions?
Your Honor, yes, there needs to be corrections made. This report was dated November 29th. It states that as of November 23rd, that Mr. Stalin was serving an upfront jail sentence, but he would be on probation for 12 months in Clinton County. That has changed. There was a probation violation in Clinton County in which Mr. Stalen's probation was revoked on January 11th. He is currently serving 93 days on that. There is another case that he was sentenced to time served on January 25th. So he's not on probation in Clinton County, he's just serving a sentence.
Make allocation.
Thank you, Your Honor. Mr. Stalen has been in custody since November, I apologize, I just want to make sure, November 23rd is my, that would put it at like 66 days at this point. He's pled guilty to a 1-year offense. He don't know if he would, he says that he would not, right now he's homeless. He doesn't have anything, but what he has in his possessions at the jail. So when he's released, he will be, he doesn't believe that he'll have the means to comply with probation. Not that he wouldn't try. He knows he wants help. He wants to seek mental health treatment in the community. But at this time, when he doesn't know what he's going to be doing when he's released, he is cleared to be out on February 27th. So with that, Your Honor, we would ask this court, if at all possible, to sentence him to time served or a small term of jail. But if the court would wants to consider probation, then if we could have, if it requires a new sentencing recommendation, we have no objection. Thank you.
Okay. He doesn't have that much credit on this one because he was out on PR bond. And so bench warrant was issued back in January. I think he was originally arraigned. He appeared in person for that. I got a note here, looks like from December 12th that he was in Clinton County. Nonetheless, he's going to be in custody for at least another 30 days. So I'll sentence him to 30 days. Which he could serve while he's in Clinton County. And I'll waive any fines and costs. You're all set.
Thank you, Your Honor.
Thank you.
Appreciate it. Have a good day.
Same to you. Okay. So Yazid's ready to go. Yeah.
Your Honor.
Back on the record in the matter of the people versus Malik Yazid. You didn't have any questions at this time, sir?
No.
Okay, so you understand that in order to plead no contest, you have to give up your right to the presumption of innocence in this matter. So you're innocent until the prosecution can prove you guilty. You understand that? You want to waive that right to the presumption of innocence today?
It was $10 only that it took, right?
I don't know what you took. I haven't read this police report.
Yeah, I'll give it more.
Okay, you're gonna give away your right to be presumed innocent, or to be considered innocent? Okay, and you're gonna give up your right to cross-examine any of the witnesses that the prosecution intends to call against you? So if you proceed to trial, then you have the right to have them call witnesses against you so they can prove this charge. You wanna give up that right? You don't?
Wait, I want to, yeah, sorry. There's only
Okay.
$10 that it took, but there wasn't no proof, but the cops out there were just wild and everything, so.
Oh, okay, got it.
Yeah, I'll give it up. I just want, I get money, I can pay it back, I can pay the court back and I can go pay it back.
Got you.
I got good money from the bank.
Do you understand what's going on here today?
I don't y'all charging me with larceny. I didn't even break into nowhere. I didn't break in nowhere. I just, it was like, about $10 out the damn tip jar type shit like that. So,
Do you know that you don't use that language in court?
I'm sorry.
Okay, we're not on the streets.
I know. I don't live on the street, but I don't know. I'm sorry. The question about
Okay.
that was different.
Do you understand these rights here?
Yes, I do. I read them all.
Okay, so you understand that you have the right to have a
I'm
jury
trying-
trial?
I'm not trying to have no jury trial. I want to go home. I don't want to take.
I didn't ask you that. Do you understand that you have the right to have a jury trial?
Yeah.
Okay, you want to give up your right to jury trial today?
Yes.
Well, you can't guess. You gotta answer these questions.
Well, what is a jury? What is a jury?
Got it. I think maybe he might need a psychological evaluation.
That's what this is, a psychological
This
evaluation.
is
What
definitely
is
not a psychological evaluation.
jury? You want me to go on a journey for a jury or some shit? What do you mean?
Okay, we're not gonna talk.
No, I don't know what you mean.
All right, remand him to custody.
No, I'm sorry. I don't know what you mean though.
Yeah, but you're not gonna have outbursts.
My
I
name's
can't-
Malik
I
Yadav. I
can't-
just don't know what you mean.
I can't conduct this
I'm trying to
hearing.
be nice. Please take it easy because I was reading and then you talked to him. Like, please, can I get a second chance, Your Honor? Please, can I get a second chance? What's going on? Am I going back to jail? What's going on?
You are going back to jail.
For how long? For how long?
I think you probably need to have a private conversation with him. And I don't know if you've had enough conversation with him, but I think based on his representations in the court today, that he does not appreciate the understanding of what's going on here today, and he needs to be evaluated.
Is the court ordering a competency evaluation, or is the court ordering that he receive evaluation from CATS from the jail?
Cats from the jail. I don't know, based on what is stated even in his police report with the use of some controlled substance, if he's having some reaction, I don't know what it is, but he doesn't understand what's going on here today. He can't control his outburst either. So I think he needs to have an evaluation. So I will order one with cats.
And if I just may make a brief record, Your Honor.
You may.
Discussion I had with Mr. Yazid was vastly different from the way he appeared here today in court. I would not have had him proceed or attempt to proceed on the record if I thought that he was not in a competent place to proceed. So it may very well be that he was having some type of psychological episode. But I just want to assure the court that his behavior here today was different from when I discussed it with him yesterday and when I had previous discussions with him as well.
Oh.
But with that, I have no objection based upon his conduct here today to the court ordering an evaluation by CATS.
Anything from the people?
No, nothing for the people, Your Honor. Thank you.
Thank you. We're off the record, and he will be remanded until the time of the evaluation. Thank you. Are we ready on Hill?
I'll bring you into the courtroom, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus William Hill. File number is 22-00080. Council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Thank you, Your Honor. Good morning, Edward Hess here on behalf of Mr. Hill. Mr. Hill is seated to my right at the council table.
How are you, Mr. Hill? Today's the date and the time that's set for preliminary examination. Are we ready to proceed?
We are at this time, Your Honor.
Defense is ready, Your Honor.
Okay, any preliminary matters?
Your Honor, just one. At this time, the people's intention is to proceed with one officer today and then ask for a continuance due to a subpoena not going out to a necessary officer, Your Honor.
Okay.
I don't have any preliminary matters, Your Honor.
Thank you. You can call your first witness.
The people call Alex Slovin.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
I do.
Thank you. You can have a seat. You can state your first and last name, spell both of them.
Alex Slovin, ALECSLOVIN.
You can proceed, counsel.
Thank you, Your Honor. Officer Slovin, where do you work? How long have you worked there?
6 years
In what capacity do you work?
as a road patrol officer.
And on the 8th of January of 2023, were you serving in that capacity?
I was.
Did you receive a call that night?
I did.
And what was that call for?
It was a troublesome subject complaint at 911 West Kavanaugh.
Is 911 West Kavanaugh in the city of Lansing?
It is.
Is that in the state of Michigan in Ingham County?
Yes.
And so you said it was a troublesome suspect?
Yes.
Subject? Sorry. Did you go to 911 West Kavanaugh?
I did.
And what did you see when you arrived?
When I arrived on scene, observed a older black male wearing a black jacket standing out front of the building, which was described in the dispatch complaint.
I'm gonna slow stop you right there for a second. And when you first arrived, did you have any background knowledge on what was potentially happening at this location? And what was that?
There was some type of dispute, and that male there had a handgun in his jacket.
So when you first arrived on scene, how far away were you?
Approximately 50 plus yards.
And then you began to approach?
Yes.
What happened when you were approaching? What were you observing while you were approaching?
As I approached, I observed the older black male with his right hand in his coat pocket, which was advised in the call that the firearm was in that pocket. Observed the male walk behind a bush briefly and then reappeared where I saw him standing. At which point I shined my flashlight on him and asked him to show me his hands.
Did you give any commands when you first arrived when you saw the hand in the pocket?
The first commands were to show me his hands once I shined my flashlight on him.
And then did he show you his hands immediately?
No.
That you saw him step behind a bush?
Correct.
Was this bush located right beside, where was the bush in reference to the subject?
It was to his right in front of him.
And about how long was he behind that bush?
The first or the second time?
The first time.
The first time it was just briefly, that was as I was exiting the patrol car.
And then the second time?
The second time was after I gave him the verbal commands to show me his hands. At that time, he immediately made a further movement behind the bush and hunkered down behind it before popping out again.
And then you approached him?
Yes.
And what happened when you approached him?
I continued to give him verbal commands to show me his hands. He kept moving around. He was kind of non-compliant. And then he was told to get on the ground due to a firearm.
Did he comply with that?
Not initially, but he ended up going to the ground as more officers arrived on scene.
And did you look around that bush?
I did.
And what did you see under that bush?
A small silver handgun.
May I approach, Your Honor?
You may.
For the record, like I'm showing in what's been marked as People's Proposed 1 and 2. You recognize those pictures?
I do.
Did you take those pictures?
I did.
Are those pictures a fair and accurate representation of what you saw that day?
Yes.
People move for admission of People's Proposed 1 and 2.
Any objection?
No objection.
People's 1 and 2 are admitted?
May I publish, Your Honor?
Yes.
Did Mr. Hill identify himself to you? I did not speak to him after the initial commands and he was taken into custody.
Is the person you saw that day sitting in this courtroom?
Yes,
Could you point out where he's sitting and describe something he's wearing?
he is sitting next to the attorney wearing a brown sweater.
Will the record reflect that the witnesses identify the defendant?
Any objection to identification?
No objection for purposes of this hearing. Thank you.
Identification is noted.
No further questions this time, thank you, Your Honor.
Oh, we can proceed with cross-examination.
Thank you, Your Honor. Officer Slobin, were you the first officer on scene?
I was.
And there were quite a few other officers that pulled up very soon after you pulled up, right?
Correct.
Okay. And the actions that you observed with the subject hunkering down behind the bush and you telling him to show you his hands and him getting down, that all transpired over a matter of seconds, is that correct? Less than a minute?
In a minute.
Okay. And it wasn't just you shouting commands, there were other officers shouting commands as well, right?
I don't recall. Giving any commands.
You recall yourself shouting commands?
Yes.
You described the individual you identified as my client as an older person, is that true?
Yes.
Did you see, did he have a red and white cane with him?
He did have a cane with him.
Was it a seeing eye sort of cane?
That I didn't observe.
All right. Now, did you observe him having trouble getting down when he was trying to get down?
No, he appeared to be walking in circles.
Okay. Now, you indicated that you observed the subject with his hand in his coat pocket, correct?
Correct.
Did you ever observe the subject holding a gun?
No.
Did you ever observe a gun on or about the subject's person?
No.
The first time you observed the gun would have been behind the bush.
Correct.
And if I'm correct in understanding, your information from dispatch was that there was a subject with a gun.
Correct.
And am I correct in understanding that because of the report of the subject having a gun, that you were alert and looking for a gun?
Right.
And you were cognizant of your safety and that of the other officers and that of bystanders? And it was your goal to locate the potential gun and to detain the subject?
Correct.
And you achieved that within less than a minute? That'd be accurate?
I agree.
Once the what you described as a silver gun was located, are you the one who took that gun into evidence?
I am.
Okay. And you're the one who took these pictures?
Yes.
I have no further questions, Your Honor.
Can you redirect?
No, not at this time, Your Honor, thank you.
May Officer Slobin be excused?
Yes, Your Honor.
Thank you, Officer Slobin.
Okay.
And the only other witness is the one that was not properly subpoenaed?
That's correct, Your Honor.
So the court will grant your request to continue this so that the officer can be properly subpoenaed. Any additional matters today?
Nothing to deal with, thank you, Your Honor.
Your Honor, I've heard and of course respect the court's ruling, but for the record, I'll note an objection to the adjournment.
Thank you. Your objection is noted.
Thank you.
Do you want the court to hold these exhibits?
I can hold them for the court, Your Honor, thank you.
Yes, please.
February 16th, 9:30.
February 16th at 9:30.
Thank you very much, Your Honor. February 16th at 9:30 a.m.
Yes.
We have that. Now, Your Honor, I'm not sure what matter the court will be hearing next. I do have to help Mr. Hill call his ride from the paratransit.
Absolutely. We can. think you're the only other one I have, so we can wait for you to do that.
Okay,
I think we have Mr. Bullock.
Well, he's in custody.
It'll take about
He's
5
not
minutes.
going He's gonna need more time, I'm sure, than that. But I'm not, I'm just assuming. Let's see.
Let's go out in the hallway, Mr. Hill, and we'll go to paragraph.
the record in the matter of the people of the state of Michigan versus Chloe DeMay, file number is 23-00088. FY, council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
On behalf of Mr. May is standing to my right of the council table.
Okay, how are you, Mr. May? Today's the date and time set for preliminary examination. Are we ready to proceed?
People ready to proceed at this time, Your Honor. Thank you.
Yes, sir.
Any preliminary matters?
No preliminary matters from the people, Your Honor. Thank you.
I don't have any preliminary matters.
You can call your first witness.
We'll call it Natasha Look.
She's in. No, okay.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. There's a microphone that's in front of you, and I have a court recorder sitting behind you. She needs to take down everything that's being stated here today, so I need your responses to be loud and clear, okay?
Okay.
I also need them to be verbal. You can't do head nods or shakes or mhm and ahas because we can't read those into the record properly, okay? If you hear an objection from either of the attorneys, you will stop speaking. I'll make a ruling on that objection and I'll let you know if you can give that response or not. Can you state your name first and last and spell both of them?
Natasha Look. NATASHALOOK.
You can proceed, counsel.
Thank you, Your Honor. Miss Look, where do you live?
532 Allen Street.
Is that in Lansing?
Yeah.
Is that in the county of Ingham,
Yeah.
state of Michigan? And who lives there with you? And who is your mom? Is she in this courtroom today? Could you please point to her and describe something she's wearing? Let the
Speak up for me.
A flannel.
Let the record reflect that the victim has identified the defendant.
Any objection?
No objection to the identification for purposes of this hearing.
So noted.
We're gonna go back to the 9th of January, 2023. Can you tell me what happened? What you remember from January 9th?
When I came home, she started yelling at me, and so I started yelling back.
Where were you before you came home?
Oh, I was at work. I came home from work.
Do you remember about what time you came home from work? So you came home from work and you got an argument started?
Yeah, the argument started, and so we started yelling at each other, and so I went to my room and I told her to leave me alone, and she came in my room and she wouldn't leave me alone. So I started being disrespectful because she wouldn't leave me alone.
And do you remember what the argument was about?
Whole bunch of stuff.
When you say that, so you went to your room and then she followed you there?
Is that a yes?
Yes,
And you said you were being disrespectful. What do you mean by that?
I told her she was a dumbass because she wouldn't leave me alone. But I asked her multiple times to leave me alone. Because I went to my room and that's where I go when I want to be alone.
And what happened after you were in your room?
Then she followed me and she wouldn't leave me alone and she kept screaming at me. So I went to leave. And when I got to the back of my room, she started throwing me around the room.
So were you in your room when she started throwing you around, or did you
No.
exit your room?
I exited.
And you were attempting to leave?
Yeah, I was in the mud room. It's like a little small room in the back of the house where the door is to exit.
Okay. And she had followed you in there too?
Yes.
And you said she started throwing you around. Can you describe what you mean by throwing you around?
She had pushed me up against the wall with her arm against me and was holding me there. And then she started throwing me on the floor. And then she started choking me. And when I gave up, she kept going.
It's okay to take a moment. Okay. You said she threw you to the ground.
Yes.
Did she hit you at any point?
No, she didn't.
You said she choked you.
Yeah, she choked me with my hoodie.
What do you remember about that?
She grabbed me and had it around my neck.
Sorry, I didn't quite hear you.
She had it just wrapped around my neck.
She had your hoodie wrapped around your neck.
Yeah, she took the hood and wrapped it around.
And do you remember, did you have trouble breathing?
Yes, I couldn't breathe. I stopped breathing when I fell down. Because I had gave up because I felt pain.
Do you recall how long did she have the hoodie around your neck? Did you begin to lose I think I already asked, did you begin to lose your ability to breathe?
A little bit.
Did you lose consciousness?
No.
And when did she stop? When do you remember her stop strangling? Do you remember why she stopped? Did you fight back?
No, I pushed back at first, but I didn't hit her or anything. I kicked her in the chest when she was getting off of me.
And when she had your hoodie wrapped around your neck, were you guys on the ground then?
Yes.
Did you eventually get away?
Yes.
Or did you call for 911 once you got away?
Yes.
No further questions, time. Thank you.
Thank you. Ms. Look, this place where you were living with your mom, this is a house that you and she were renting together, is that right?
Yes.
So even though she's your mom and you're her daughter, it's correct to say it's like a roommate situation, right?
Yes.
Okay. And you and your mom definitely had some things that you were upset at each other about, is that right?
She had something she was upset at me about.
Okay. Well, you were upset enough with her that you wanted her to leave you alone, right?
Yes.
Okay. And was she upset with you because you had stopped cleaning the house?
Yeah.
Okay. And had you stopped cleaning the house because you were upset with her for not buying groceries?
Yep.
Okay. So it's fair to say this was a dispute that the two of you were having regarding your household situation.
Many other reasons too.
Okay.
Many.
In addition to other reasons, you were having a dispute regarding your household situation?
Many other reasons. That was the least of it.
Okay. Okay. So I'm not, it's not, I don't think it's that relevant to this case. I'm not going to get into details of your personal life. Sounds like you had a lot of reasons to be unhappy with your mother. Is that true?
She was unhappy with me. I came home happy for her.
Okay. Then the argument started when you came home?
Yes.
Okay. Now, eventually, you insulted your mother using some vulgarity, right?
Yes.
You called her a fucking bitch?
No.
You called her, what were the words you used before? Dumbass?
I said she's a fucking dumbass.
Okay, fair enough. And your mother asked you to say that to her face?
Yep.
Okay. And is it at that point that you turned around and approached your mother aggressively?
When I was walking out my room?
Yes.
Yes. When I was walking out my room, I guess I did.
Okay. And when you were approaching her aggressively, your mother pushed you back, is that right?
No.
Okay. When was the
Nope.
first physical contact? In the mudroom?
Yes.
Okay. And was that physical contact, were you face to face with her?
I don't remember.
Do you remember where you were shoved?
Yeah, into the back of the room.
Was the shove to the front of your body?
She pushed me from the front.
Okay, so you were facing her and she was facing you.
Yeah.
And the reason she shoved you is because you were approaching her aggressively?
No, I was trying to leave.
Were you swearing at her?
No, I was trying to leave.
Were you attempting to fight her?
No, I was trying to leave.
Were you attempting to injure her?
No, I wanted to leave.
Okay. Now, at that time, you indicated something regarding your hoodie. Were you wearing a hoodie at the time?
Yes.
Okay.
I'm wearing the hoodie right now.
Okay, that's the sweatshirt that you're wearing underneath your coat?
Yes.
Okay. Now, do you remember talking to police about this encounter?
Yes.
Do you remember telling police that you were not in fear of your life during this encounter?
Yes.
Do you remember telling police that you did not lose consciousness?
Yes.
So isn't it true that your mother never put her arms around your neck?
No, she never put her hands on my neck.
Okay, so this so-called choking you're talking about is by your shirt, by your hoodie?
Yes.
Okay. And is that because your mother was restraining you against the wall?
No, I was on the floor.
You were on the floor. Your back was on the floor?
Yes, my back was on the floor and she was on top of me.
And you testified that when she stopped restraining you, that you kicked her in the chest? So you were attempting to injure her
No,
while
I
she
was
was
trying to
restraining
get
you?
her off of me.
Okay,
Kicked her as she like up, like she's not up, but she's like sitting on top of me and I kick her chest off me.
and did that get her off of you?
Kind of, I think she was already done at that point.
And after that, you left the room?
I ran out the front door, yeah. I had to run to the front of the house to get out.
You ran to the front door?
Yeah,
The mudroom's in the back?
yeah.
So is it your testimony that you fell to the floor after your mother shoved you?
It was like, my body gave out. I felt like that. Couldn't stand anymore. Muscles gave out.
Okay. And when you were on the floor with your mother, she was holding you by the hoodie?
No, she was on top of me. I couldn't move.
Okay.
She was sitting on top of me.
Where were her hands?
I don't remember.
Okay. But they were not on your neck, right?
No, she didn't put her hands on me. She
Okay.
choked me with the hoodie.
Well, you said you don't remember where her hands were. Why do you say she choked you with the hoodie?
Because I could feel the hoodie choking me on my neck.
You felt the fabric digging into your neck?
Yes,
Okay. And during this time, were you struggling?
yes,
Were you kicking?
yes.
Were you flailing with your arms?
No, my arms weren't, like I couldn't move my arms.
Okay. You were kicking with your feet? Okay. What about your torso? Were you trying to push yourself up? Okay.
But I'm only 106 pounds.
Okay.
That's not doing anything.
Okay. And would you say this confrontation lasted a few seconds?
Minutes,
A few minutes?
if it's 5-7 minutes.
Okay. All right. No further questions, Your Honor.
Yes, briefly, Your Honor, thank you. At some point, did your mother push you up against the wall?
Yes,
What happened when she pushed you up against the wall?
she had her arm up against me. And then I started to get faint because I was sitting there trying to push her off of me.
Where was her arm at when she had you up against the wall?
Right here,
Can you just
like on my chest. And it kind of,
let the record reflect that the witness is holding her arm just under the neck area, right across the top of the chest where it would cross over the neck as well.
And did you have trouble breathing? So when you were on the ground, let's move back into when you were on the ground, and you said that she was on top of you. How was she on top of you?
the shadow.
Okay, and during the time that you were being strangled, you said you didn't lose consciousness, but did you feel any other effects besides losing?
I was very dizzy. That's why I gave out and let my body fall to the ground. And then when she started choking me, that's when I started to really lightheaded.
And I know defense counsel, asked you if you were approaching aggressively. Were you approaching aggressively or were you just in a hurry to leave?
I was just in a hurry to leave.
Thank you. No further questions, Your Honor.
Thank you. I am just a little confused because a question about her being choked. Did your mom put her arms around your neck at all?
No,
Well, when you say choke, what are you talking about?
she used the hoodie, put it around my neck and was pulling it. and
Okay,
choking.
you were wearing the hoodie?
Yes,
So the hoodie that you're wearing now?
yes.
Okay, so you're saying she pulled it
She took it like this.
and wrapped it around your neck?
Yes.
Okay, sounds good. Thank you. Any further questions based on that?
One, very briefly. Was that at the time that you were on the ground and she was on top of you? Was she,
That a yes?
and she was essentially pinning you down by your neck?
Yes.
No further questions, Your Honor. Thank you.
Any cross based on my questions?
Yes. Ms. Look, you said you didn't remember where your mother's hands were when you were on the ground, right?
Yes.
So what you just testified to the court about your mother taking the hoodie and wrapping around your neck, that's not based on your observation of what was happening, is it?
Well, obviously she did it. Nobody else wrapped it around my neck.
But you didn't know where her arms were, right?
Obviously on the hoodie, I wasn't choking myself.
Was the
What are
hoodie,
you asking me?
was the hood underneath your body?
No, it was on my body. I was wearing the hoodie.
No further questions, Your Honor.
Okay, I think the question though, that he's asking you was, did you see her hold that hood around your neck like that?
Yes.
Okay, so you could see her hand
I
holding?
could, yes.
Okay, that was what the question is. Okay, any further questions?
No further questions this time. Thank you,
May
Your
this
Honor.
witness be excused?
Yes, Your Honor.
You may be excused, Ms. Lord. You can call your next witness.
People rest this time, Your Honor.
Any defense witnesses?
No, Your Honor.
You can proceed to argument.
Thank you, Your Honor. We heard testimony from the victim in this matter, Your Honor. She testifies that there was an argument that took place, Your Honor. She didn't shy away from the fact that she did disrespect her mother at some time, Your Honor. She testified that she wasn't walking aggressively, wasn't approaching aggressively when she was leaving. She was just in a hurry to leave, Your Honor. She was trying to leave, but the mother wasn't going to let that disrespect fly, Your Honor. Here at that time, Your Honor, she testified that they went into the mudroom. At that time, her mother began to shove her and at one point pinned her up against the wall with her arm across her chest and neck area. And then shoved her, and then she lost her motor control at that point, Your Honor, and fell to the ground. She testified that her mother followed up on top of her and began to was straddling her, choking her with the hoodie and had it around her neck, pinning her to the ground by it, Your Honor. She testified that she lost her ability to breathe, Your Honor. She became lightheaded and her vision was blurry at that time, Your Honor. Your Honor, at this time, I think there's sufficient evidence to bind this over on the charges in the complaint, Your Honor, and I would ask that you do so. Thank you.
Mr. Hess.
Thank you, Your Honor. The people have presented one witness today, Natasha Look, the complainant, the alleged victim. The court has a duty under People versus Anderson in making its mind over decision to consider the credibility of witnesses. Now, Ms. Look contradicted herself in her testimony. She talked about not seeing where her mother's arms or hands were. And then upon further questioning, she decided that she saw her mother drawing the hood across her neck, perhaps in an effort to convince the court that a crime had been committed, to conform her answers to what she thought the prosecution might want to hear. When I asked her, was she shoved against the wall at some point? She testified no. And then upon further questioning, I believe by the prosecutor, she decided to testify that in fact, she was shoved against the wall. Your Honor, it's clear from the testimony that this was a mutual affray. This was a roommate dispute. This is a mother and daughter going through some tough times in life, unhappy with each other, obviously concerned some household matters. Also, as Ms. Look said, very, very unhappily, a lot of other matters. And I'm not looking to dissect their whole personal lives. She apparently had a lot to be upset about with her mother. Now, when I questioned her, she said that she left the room aggressively, that she approached my client aggressively. My client doesn't want to be attacked. She's got the right to push this aggressive young person back from her. She has the right to restrain this aggressive young person from attacking her. The allegation here is of assault by strangulation or suffocation. So, first of all, the prosecution has to prove that a battery was committed. We know that a battery is a forceful, violent, or offensive touching of another person. I'm just reading off of criminal jury instruction 17.35 to make a record of that. And second of all, the touching must have been intended. Well, how can you have an intentional choking when the witness testified that Ms. DeMay did not have her hands around her neck and that she felt like she was being choked by the hood being wrapped around her neck? This is, even if the court finds it credible that she says she had trouble breathing, there was no testimony on record that Ms. DeMay in any way intended to choke or strangle her daughter. The testimony is that this was a mutual affray between the two. So it's my position to the court, Your Honor, first of all, that Natasha Look is not a credible witness and the court should discount her testimony. Second of all, that there has not been testimony presented to a probable cause standard that Ms. DeMay intentionally tried to choke or strangle her daughter. I'm asking that this case be dismissed. Thank you, Your Honor.
Any further argument from the prosecution?
Very, very briefly, Your Honor. Your Honor, when we talk about the intent can be shown by the actions of the individual. And Your Honor, the way that the victim described that hood going around her neck, Your Honor, there's no doubt as to what her intention was. You can't accidentally wrap a hoodie around somebody's neck, Your Honor. So it wasn't an accidental and it was intended, Your Honor. Thank you.
I don't think she said, I think the discrepancy is that the testimony was that she couldn't see her mother's hands and that it's obvious that she must have wrapped it around her neck. And I believe what the defense is arguing is that's not actually obvious. Maybe it was a result of how she fell, and that she later changed or altered a portion of her testimony to satisfy the court's question as to how the hoodie got wrapped around her neck. Nonetheless, I don't require you to give any further argument based on that. I'm just trying to clarify the testimony and the arguments as they have been presented to me. Today is the date and time set for preliminary examination, Ms. DeMay, and at the time of preliminary examination, the burden is squarely upon the prosecution. They need to bring forth sufficient evidence to satisfy probable cause. It's a relatively low burden, probable causes. It's more than just mere suspicion that a crime was committed, but not nearly as much evidence that would be required to prove your guilt beyond a reasonable doubt at the time of a trial. So this is evidence that is presented at today's hearing. It's based on testimony. The court is the sole determiner of credibility. I can believe all or portions of a victim's or witness's testimony and determine whether or not I believe there's reasonable evidence as to the doubt of any of the guilt alleged here. Today, we did hear testimony from Natasha Look, the alleged victim in this matter. She testified that on the date of January 9, 2023, in the area of 532 Allen Street, City of Lansing, Ingham County, State of Michigan, making venue in this court appropriate, that there was an altercation or incident that took place in the home that she occupies and resides with her mom, who she later identified as the defendant in this matter, Chloe DeMay. He testified that there was some yelling back and forth, and that she admitted to disrespecting her mom, calling her out of the name, and that she attempted to leave. I think it was later on cross determined or brought out that she may or may not have approached her mom aggressively, and that she was pushed and then pushed around the room and later was choking. We recognize based on the testimony that there was no choking that actually took place. Actually, there was no choking that took place regardless, because choking is something that's going on the inside of your throat. What she was describing as choking would have been strangulation. The question before the court is whether or not there was an intentional action taken by the defendant to cause the hoodie or the hood to the hoodie to be wrapped around the victim's neck in order to cause her to be strangled or suffocated. That remains a question of fact. I think that the testimony based can be, based on what Ms. Look said, that the actions could be inferred that that was action that took place. I don't think that Ms. Look was able to observe the defendant's hands to appropriately testify as to whether or not that was an intentional action or not. There's also a question of fact as to whether or not the defendant took actions in which she thought was reasonable for self-defense because of the testimony providing or indicating that Ms. Look approached her mom aggressively prior to being shoved. With that being stated, though, defense and self-defense is something that's most appropriately addressed at the circuit court. And so for the purposes of today's hearing, the court is satisfied that there is sufficient probable cause to bind over as charged. So the matter will be bound over to the circuit court for a bind over date of February 8th. You do not need to appear in court on February 8th. That's the date that they get the file from this court. Your next court date will be in circuit court, and it will be a pretrial. You and your attorney, Mr. Hess, will be made aware of that date. Okay, ma'am?
Yes.
You have any questions for the board today? Any additional matters for the record?
Nothing about the people. Thank you, Your Honor.
Your Honor, the additional matter that I have is regarding bond conditions. We thank the court for allowing Ms. DeMay to visit her home and to get some of the items. However, the unfortunate situation remains that she and Natasha are the co-lessors of this residence. Now that this case has been bound over, we don't know how much longer it will continue. Ms. DeMay has almost all of her earthly possessions inside this house, including appliances, clothing, personal effects, her dog, other items of sentimental and practical value. Your mother's, oh, I'm sorry, some remains of her mother. And I'm respectfully asking that the court allow Ms. DeMay an extended visit to the home with help to remove as many of her possessions as she can. She wants to respect the no contact order with Natasha, and she has been respecting it as far as I'm aware, but it's very, very difficult for her to essentially be living with the clothes on her back as she still remains locked out of the house due to this court case. So I'm asking the court enter an order saying that under police supervision that Ms. DeMay may have a few hours or an entire morning or an entire day to go and basically move out of the residence, Your Honor, because right now it's not, I'm not going to say it's Natasha's fault. It's a court order, but Ms. DeMay's things are all essentially being held hostage, and there's very little she can do about it. So I'm asking the court to modify bond in order to allow her to move out. Thank you.
Does she have a move out date set or arrangements where she can move her things to?
Ma'am, you can answer that for the court better.
I can have those arrangements maybe within a week.
Okay, well, why don't we get some arrangements so that we know a time frame that could be narrowed down, and then because there's no possible way the court can order law enforcement to sit for several hours and or a day while someone moves out. What's better suited is to make arrangements and make an order that the victim is not at the house during this time frame so that she can get those things.
Sure.
But if I would need to know a date and time prior to in order to make that order.
There's no contact. Thank you, Your Honor. What was the bind over date again?
Bind over date's February 8th.
Okay, so I appreciate that, Your Honor. It sounds like the court will still have jurisdiction until that bind over date. So I'm going to ask Ms. DeMay to make those arrangements. Call me as soon as they've been made, and I'll work with Mr. Ring to reach a stipulation as to what might be appropriate to let Ms. DeMay move out. We'll submit that to the court.
Sounds good. Any additional matters for the record at this time?
Nothing about the people. Thank you, Your Honor.
Nothing further. Thank you.
Thank you. You're all set.
Thank you, Mr. Mayor.
Okay, last, and certainly not least. Where's Mr. Ring? You can be seated.
Your Honor, can I have like 30 more seconds to go? Let a witness go, then, well, based off this information that I just received.
Sure.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Jacob Bullock, file number 22-035779, council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Morning, Your Honor. Jared Austin appearing on behalf of Mr. Bullock. He is present with me at council table.
Thank you. Today's the date and time set for a preliminary examination. We have one count of assault with intent to degrade bodily harm less than murder or by strangulation, and count 2 domestic violence with the second offense notice. And then I also have a PA 53 violation that you need to be arraigned on. How are we proceeding at this time?
Your Honor, it's my understanding from speaking with Mr. Bullock, he would be exercising the statutory right to have a preliminary examination. And I also believe that he will be admitting to the no contact violation.
That's correct, sir? Okay, so I have a report here, case number 22519111352, which is the police report that was entered on January 25th, 2023 by Officer Scasia, alleging that there was a violation of the no contact order, that you were arraigned by Magistrate Milmore on the underlying file back on on January 11, 2023. There was a no contact order. The allegations that you violated the no contact order, preventing you from making contact directly or indirectly with Angela Bullock, says that the Securus located 17 attempted phone calls, 11 completed phone calls from your Securus account with your PIN number to phone numbers associated to Angela Bullock. Officers also located 41 attempted and 29 completed phone calls from the defendant to another phone number used or as associated to Angela Bullock, that information being uploaded to evidence.com. There is a attachment of phone logs as well as some video an individual that looks just like you, Mr. Bullock, and a lady identified as Angela Bullock. And so you have the right to have a contested hearing on that. You have the right to have the prosecution put forth sufficient evidence to prove beyond a reasonable doubt that you violated your bond conditions. And if you are found to be in violation of your bond, you're subject to your bond being revoked. You can be remanded to custody. You can have your phone privileges restricted for the remainder of the time that you're remanded to custody. You also can be faced with a contempt of court order for violating the court orders, and contempt of court is punishable with a maximum penalty of 93 days and or $7,500 in fines. Do you understand that? Okay, you want to waive your right to have a hearing on this? You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? I'm sorry?
Yes, ma'am.
You can put your hand down. Anybody threatening you to get you to waive your contested hearing today?
No, ma'am.
Any promises being made to you in exchange for you waiving your hearing?
No, ma'am.
Are you pleading guilty to the violation because you believe you're guilty?
Yes, I take full accountability.
Okay, as to the violation or the allegation that you violated your bond conditions by making unauthorized contact to the alleged victim in this matter, Angela Bullock. Do you plead guilty, not guilty, or stand mute?
Guilty.
You said guilty because what?
Because I reached out to her yesterday.
You said yesterday?
No, because I reached out to her.
Oh, okay, thank you.
Yesterday.
Okay, any additional factual basis?
I'm satisfied, Your Honor.
People are satisfied, Your Honor. Thank you.
Court is also satisfied with the factual basis. I'll accept your plea, trying your plea to be made freely, voluntarily, and intelligently. You said we are going to proceed with the exam as well?
That's correct, Your Honor.
Okay, we'll address sentencing after the exam.
Thank you, Judge.
No, no problem. You can be seated. You can call your first witness, unless we have some other preliminary matters.
No other preliminary matters on behalf of the people. Thank you, Your Honor.
No preliminary matters on behalf of Mr. Bullock, Your Honor. Thank you.
You can call your witness.
Your Honor, at this time, people will call Officer Farian Chang.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat, officer. And can you state your first and last name, spell them both?
My first name is Farhan, spelled as F-E-I-R-A-N, and the last name spelled as C-H-E-N-G, Chang.
You can proceed.
Thank you. Officer Chang, where do you currently work?
I'm currently working in the Lansing Police Department.
In what capacity are you employed in the Lansing Police Department?
I'm a patrol officer,
How long have you been employed as a Lansing Police Officer?
approximately 2 years.
Okay, officer, I'm gonna take you back to November 29th of 2022. Were you working as your capacity as a police officer on that day?
Yes,
Were you working alone or with a partner?
I was working alone.
Were you in a fully marked car?
Yes,
How were you dressed on that day?
I was fully dressed in LPD patrol uniform.
And on that day, were you dispatched to 426 South Francis Avenue?
Yes,
Is that in the city of Lansing,
yes,
Ingham County, Michigan?
yes.
Why were you dispatched to that address?
We received a call for service with a victim complaining of being assaulted and she was injured.
Did you show up?
I did.
And who was on scene when you showed up?
The victim, Angela Bullock, and 2 other relatives that were not identified.
Did you talk to anyone on the scene?
Angela Bullock.
And did she name who did that to her?
Yes,
Did she disclose the nature of the relationship that she had
Yes.
to that individual with you?
yes,
Your Honor, I believe at this time I've laid a proper foundation for the statements to come in under MCL 76827C.
Mr. Austin.
I believe foundation has been laid as part of the domestic relationship, done that. I think it's the statements themselves. I think we'll have to get into that more to determine the liability of that, but I think they can proceed at this point. If there's an objection to be made, I will make the appropriate objection.
Thank you. You can proceed, counsel.
Thank you, Your Honor.
And so when you first made contact with Angela Bullock, how was she?
She was injured and she was very, very emotional and agitated.
And when you say, was she in the home or was this outside when you first made contact with her?
She was in the home, in the living room.
Did she answer the door for you?
Yes,
And when you say she was injured, did you observe injury yourself?
I did.
What did you observe?
She had a open wound to the back of her head, and it was clear that she had been bleeding.
And did she tell you who did this?
Yes,
Who did she say did this?
Jacob Bullock.
And did she tell you how she was related to Jacob Bullock?
Yes,
How was she related to Jacob Bullock?
they were married.
And so what did she tell you happened?
She told me that she was coming back home and she found Mr. Bullock was inside of her residence, and she demanded Mr. Bullock to leave her home.
Did she say if Mr. Bullock was supposed to be in her home?
She said he was not supposed to be in her home.
And then she arrived home and found him home?
Yes.
Okay, go ahead. What happened after that?
And then a verbal argument occurred between victim and Mr. Bullock. And at one point, Angela's told me that she was assaulted by Mr. Bullock throwing a phone at her.
And did she say where the phone hit her?
Yes, to the back of her head.
Thank you. And after she told you that he threw a phone that hit her in the back of the head, did she make any other statements?
Yes, Angela said Mr. Bullock strangled her with both of her hands, and she had a hard time breathing.
And when she was telling you this, what was her demeanor?
That she was still very agitated and emotional.
And were you able to locate a person by the name of Jacob Bullock
Yes,
on the scene that day?
and no,
Did you search in your computer in Lean for a Jacob Bullock?
I did.
Can you describe what happens when you type in a name in Lean?
I will get a multiple result, including Mr. Bullock's SOS picture, and also if he has any active warrants or court orders.
Did he have any active court orders?
Yes,
What was that?
it was a no contact order to prevent her from prevent Mr. Bullock from contacting Angela and prevent him from conducting any assaultive or threatening manner.
And did you look at his Secretary of State picture?
I did.
And when you searched for Jacob Bullock, did you search just by name, or was Angela able to provide you with a date of birth or any other
Full
information?
information, date of birth, full name.
And then, so the picture and the name that you pulled up in Lean matched Jacob Bullock,
That's right.
and you had a chance to view that picture?
Yes,
And is that person sitting in this courtroom today?
correct.
Could you point to that person and tell me something they're wearing?
He was sitting at a corner with a dark colored jumpsuit and face mask on, eyeglasses.
May the defendant remove his mask so that the officer can see.
Yes.
Is that the person that you saw in that Secretary of State picture in your Lean?
Yes,
Thank you. Let the record reflect that the officer has identified the defendant.
Any objection to identification?
Just have a brief board here on that, Your Honor, if I may.
May?
Morning, officer.
Morning.
The picture that you were looking at on the Secretary of State records, do you know how long prior that picture was taken?
I could not remember exactly.
And when you said Mrs. Bullock gave you full information for the person that you said assaulted her, did she give first and last name, or did she give a middle name?
First, middle, last name, and date of birth.
And did you confirm all of those things when you were reviewing the Secretary of State records?
I did.
Was there any other names or records matching that person's name?
No.
Thank you, Your Honor. I have no further questions.
Thank you. Any objection to identification?
I leave it at the court's discretion, Your Honor.
Identification is noted.
Thank you, Your Honor. So Did you conduct an investigation at the scene?
I did,
Did you determine that an assault had taken place?
yes,
Did Miss Bullock leave at any point?
she did,
Did she go to the hospital?
yes,
Did you go with her?
I did.
And did she elaborate any more on what happened while you were going with her to the hospital?
No,
And after she was seen at the hospital, did you have any additional contact with Angela?
yes.
And what was the nature of that?
We received an alarm call from her residence. So we were going to her residence to make sure that the residence is actually secured. And at that time, Miss Bullock had came back from the hospital to make sure she could lock the door.
And at that time, you already said you observed an injury. Was the injury still bleeding?
No,
At that time, did she elaborate any further on what had happened with Mr. Bullock?
she told me the details about the assault during the second contact.
And what did she say happened with those details?
That she found Mr. Bullock was at her home, in her home, and she demanded him to leave. Verbal argument and assault happened subsequently.
And did she describe when he was strangling her?
She described the incident as after she was hit by the phone in her head, she was choked by Mr. Bullock with both of his hands.
Did she say if they were wrapped around his neck
Yes,
or her neck?
Her.
Sorry. Did she say she had a hard time breathing?
yes,
Did she say she lost consciousness?
no,
She said she did not.
she
lose
did
consciousness.
not.
Thank you. No further questions this time, Your Honor. Thank you.
Prosecutor?
Sure, thank you. Morning again, officer. So you were describing Miss Bullock's demeanor as emotional and agitated, is that correct?
Correct.
And this was, when you first arrived, this was the first time that you'd ever seen or interacted with Mrs. Bullock, is that correct?
Correct.
And is it fair to say that you don't know what her normal demeanor is that correct?
Correct.
And you have no way of knowing whether she's normally emotional or whether she's normally calm. Would that be correct?
At the first contact, that'd be correct.
And you were talking about an injury and at some point that was bleeding, is that correct?
Yes,
And I believe you described that in your report as a superficial injury, is that correct?
correct.
And did she ever show you a phone or locate, or did you ever locate a phone?
No.
You said that's what Mrs. Bullock said that she was struck, is that correct?
Correct.
And did you say there were two other relatives in the house when you arrived as well?
Correct.
And you did not learn the names or identity of those persons?
Correct.
Were they adults?
Yes.
Do you know if they were relatives of Mrs. Bullock or Mr. Bullock?
I believe they're relatives of Mrs. Bullock.
And you did not speak to them or gather any statements from them, is that correct?
All I learned while I was on scene is they arrived after the fact and they did not witness this incident.
So the incident that Mrs. Bullock was describing, other than her, there was no other witnesses to your understanding that would have seen that.
Correct.
And when you first arrived and spoke with Mrs. Bullock, is it fair to say that she wasn't entirely cooperative?
Correct.
And she was not very forthcoming with her information first time you had contact with her, is that correct?
Correct.
And you never had contact with or spoke with Mr. Bullock about this incident, is that correct?
Correct.
And you did not see or observe any type of markings or bruising around Mrs. Bullock's neck, is that correct?
Correct.
Thank you, I have no further questions.
Thank you. Can you read the rest?
Very briefly, officer, when you labeled that wound to her head as superficial, were you just judging, what were you basing that observation off of?
Based on her bleeding status and also based on my observation of how the wound looked like.
How much blood was there?
I cannot give a measurement.
Was it a lot, a little bit, a lot?
It was more than a little bit because she had to use multiple paper towels to wipe it and put pressure on it to stop the bleeding.
Thank you, officer. And she told you that it was Jacob Bullock that threw that phone?
Yes.
No further questions, time, Your Honor. Thank you.
Thank you. May this witness be excused.
Yes, Your Honor.
Thank you, Officer Chang. Can you call your next witness?
At this time, the people rest, Your Honor.
Is the defense calling any witnesses today?
We'll rely on the evidence presented, Your Honor, thank you.
We should proceed to argument.
May I have a brief second, Your Honor?
Absolutely.
Thank you. Yeah, thank you. We've heard testimony from Officer Chang, who arrived on scene to a very emotional and agitated victim, Your Honor. He arrived on scene and she was bleeding from the back of her head at this time when he saw her. She was bleeding enough that she thought she might need medical attention and did go to Sparrow. She explained to the officer what happened to her, who did it, Your Honor. She told the officer that Jacob Bullock threw a phone at her and it hit her in the head, causing her to bleed. She said that Jacob Bullock did strangle her by using two hands around her neck, Your Honor. She described the detail in which she described this in a little bit of detail which happened about what happened. At this time, she was very emotional. She was very upset. Officer Chang told you that he did have another contact with her, and that other contact that he was able to speak with her, and she cleared things up a little bit more, giving a little bit more detail about the incident that occurred, Your Honor. Your Honor, at this time, I do believe the people have met their burden of probable causes. There was a strangulation and that, or by great bodily harm, but bleeding on the head and seeking medical treatment, Your Honor. I would ask the court to find this matter over. Thank you.
Mr. Austin.
Thank you, Your Honor. Understanding, of course, that the burden at this stage is probable cause, which is a low burden, but it is a burden that they must meet. We only heard testimony today from the officer. We did not hear testimony from any fact witnesses today. Not hear testimony from Mrs. Bullock. So the court cannot possibly judge her credibility because she wasn't here to testify. There's no other corroborating evidence of these strangulations. The officer did not witness any marks or bruising would suggest that there was a choking or a strangulation. There was no one else that would possibly witness this other than Mrs. Bullock. And the officer is merely repeating what he was told. And I would ask the court to take that into consideration, Your Honor, when judging the credibility of the testimony that we heard today. And I would ask the court to deny the people's motion for finding.
Thank you. Mr. Bullock, today was the date and time set in this matter for a preliminary examination on one count of assault with intent to do great bodily harm less than murder or by strangulation. Count 2 is a misdemeanor of domestic violence, so it's not subject to the examination today. The purpose of the examination is to allow or to require the prosecution to meet their burden to establish that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you as a defendant who committed the crime. This is not a burden that should be compared to the burden of proof that they would have to establish if this matter proceeds to trial. At trial, they need to prove each element of the charge being brought against you beyond a reasonable doubt. It's a very high burden. This is a relatively low burden, requires more than just mere suspicion that a crime was committed. So with that being stated, the court would be the sole determiner of credibility. Today, we had the testimony of only one witness, that was Officer Farron Chang, the Lansing Police Department officer who allegedly responded to the scene of 426 South Francis Avenue, City of Lansing, Ingham County, State of Michigan, on November 29, 2022, making venue before this court appropriate. Testimony was solicited under 768.27C about an incident that was relayed to him from the alleged victim, Angela Bullock. And she described to the officer an incident where she stated that she arrived home and found the person that the officer identified in court as the defendant, Mr. Bullock, in her home, and that this was in violation of a protective order that was already in place, and that she demanded for the defendant to leave the home. That argument ensued, and that the defendant threw a phone at the back of Ms. Bullock's head, and Ms. Bullock told the officer, reported to the officer, that she was also strangled by the defendant. He used both hands, and that she was unable to breathe. The officer described the wound, and that there was some bleeding to the back of her head, to which she was transported or went to the hospital to receive some level of medical treatment, and that the victim appeared to be agitated, upset, and emotional at the time that she gave this report. And she provided the officer with the full name and date of birth of the defendant, and that indicated that that defendant was her husband. And the officer was able to identify the defendant based on information located in the law enforcement information network. The court believes that the information provided through 27C is that which is relevant and trustworthy. And so with that being stated, as to count one, assault with intent to do great bodily harm, less than murder or by strangulation, the court is satisfied that there is sufficient probable cause based on the testimony presented through the officer that there was a strangulation, as well as an assault that involved a phone being thrown at the back of Ms. Bullock's head. And so the court will bind over count one to the circuit court for further prosecution. Count two will accompany count one. Your bind over date's going to be February 8th. That's the date that they get the file from this court. That's not a date that you need to appear in circuit court. Okay, sir? Your next court date is going to be in circuit court, but it'll be a pre-trial, and you and Mr. Austin will be made aware of that date once the circuit court sets it, okay? Do you have any questions about the bind over at this time? Okay, you can proceed to make allocution about the PA 53 violation.
Your Honor, thank you. Mr. Bullock admits to violating court's order. It's a very sensitive situation for him because the complaining witness is his wife. What I can say, Your Honor, is that there did not appear to be anything in the context of the messages or the visits that they had that would result in any type of witness interference charges or seem to be anything threatening or violent or assaultive. I don't believe in the nature of the contact that they were having. Obviously, Mr. Bullock, it's been impressed upon him that this is a court order, and he is going to have to follow that order, however difficult that may be for him, because he knows that his liberty is at stake if he continues to violate. He may lose his bond. He may have to serve a jail sentence apart from any sentence that the court may impose on his matters pending here, or the matters pending in this case that's ultimately going to the circuit court. He'd end up losing his jail or his phone privileges while he's in custody of the jail. I would ask the court to continue his bond, Your Honor. I would ask the court to consider sentencing Mr. Bullock for the violation to term of jail and hold that in abeyance and have that contingent upon there being no further violation of the court's orders. And I believe that Mr. Bullock will follow through with that and will follow the court's pretrial release orders to the T. Thank
Mr. Ryan, did you?
No, I just had a couple things that I'd like to make the court aware of. At the time this alleged did occur, Mr. Bullock was on probation through this court under the special status of 7694A when this incident did occur, or was alleged to have occurred, Your Honor, that we just bound over to the circuit court. Your Honor, I would further that there is a violation in that as well on a separate incident, a matter pending before this court, Your Honor. And I would just point out that there were numerous alleged violations. I do not think the defendant has the capability of following this court's orders, Your Honor.
Thank you. Mr. Bullock is or was under a numerous court orders, I believe, to not have any contact directly or indirectly with Angela Bullock. We've had this conversation many times. Mr. Bullock would have liked to represent to the court that these allegations of contact were just a figment of people's imaginations, but we see, based on the evidence attached to the PA 53 violation, and we can even read through JPay the promises that are being made of future contact once you get out, and what you intend to do once you get out. Whether or not that constitutes witness interference, I'll leave that to the prosecution to determine if they want to issue charges for that. But the court does not believe that you understand or appreciate the seriousness of the no contact order. You are going to do what you want to do, and you care less what the court order is. Well, that's been evident or evidenced by the 17 attempted phone calls, 11 that was completed, and also 41 attempted phone calls, 29 of which being completed, 6 video chats reported in Securus. This is just in January. This is not, a long period of time that we're talking about here. And then JPay, screenshot video images that are attached in e-messages, all indicating that after being arraigned only on the 11th of this month, we're here with a multitude of violations and contact that you knew you were not supposed to have. And so because of that, I think the court has no choice but to revoke your phone privilege. You'll be able to make phone calls to your attorney only. Your bond, which was set at 10,000 cash surety, will continue. No contact order again will be reiterated. You will have to have GPS tether. You're not to be within 2,000 feet of the exclusion zone, which is wherever the victim lives, works, or goes to school. Do you have any questions and/or confusion about what the no contact order entails, sir?
I just wanted to say I apologize to the court for violating my bond, my bond requirements. I do take full accountability for everything that I've done. Regardless if I was in a vulnerable state, not going, this is rough. It's my first time ever being in jail, and I miss my wife dearly. I never knew what to do. I was confused, not knowing where my life was going here. But I don't want to make no more excuses since I've been locked up. I'm in trying to get more closer with the Lord, reading the Bible, doing some reading, even taking steps further to go to CMH, which I have been doing prior to even getting arrested. I just want you to know everything that I set to do. I've been doing my hardest and everything to do with my license, trying to go to work, and even taking my mental health serious. It's stuff that I've been denying and not even taking notice of that. But there's no excuse of me reaching out and breaking my contact. I take full accountability. I've been learning to do that a lot and not make excuses for myself as a man.
Thank you for that. And you're the only person who can be in control of your behavior. I can tell you what I don't want you to do, but it's up to you as to whether or not you're going to do those things. It's important that you prioritize your mental health, since that's been an underlying factor in this matter and other matters that have brought you before the court. And so get the help that you can. And I think that we have another matter pending for him. Is that correct?
That's correct, Your Honor. We have a misdemeanor bond violation matter.
Oh,
pending before.
and another file.
That's correct, Your Honor.
We'll address that at another time. Any additional matters for the record?
Your Honor, could you please reiterate to Mr. Bullock that means not using any other inmates' accounts to contact the victim?
Absolutely. So the no contact order means you can't contact directly or indirectly. You can't cause anyone else to make contact on your behalf. You also can't use anybody else's PIN number or JPay account to make contact. There's no communication, no smoke signals. You can't use any Morse code. Nothing that could happen that would convey a message from you to Ms. Bullock. Do you understand that? Okay. Any additional matters for the record?
Nothing else will be able to. Thank you, Your Honor.
Nothing further on behalf of Mr. Bullock, Your Honor. Thank you.
You're all set. Thank you.
Thank you, Judge.
Okay. I think that completes our criminal docket today. Mr. Ring, is that correct?
That is correct, Your Honor.